right, good evening everyone, and welcome to my first class here. And the topic that I have decided to take up today is, as you can see it on the screen, procedure established by law and the due process of law. So procedure established by law and due process of law are two of the most important elementary foundational concept of the entire legal system. I would use the word the legal system of our country, India. Okay, so there are like various aspects and like there are like various facets which is related to due process of law and procedure established by law regarding the legal system of India. So we are going to understand the entire concept of procedure established by law and due process of law. So which is very important, and as in like regardless of like you are preparing for your prelims or the mains of your civil service exam, so these two are one of the most important aspects of your preparation process. Okay, so take it up as a very important topic for your preparation, and you can definitely expect questions, especially in your mains. Okay, all right. So without any further ado, so what I'll do is this: I will directly go to the topic now. Before trying to understand what exactly in the Indian constitution or in the Indian legal system, what exactly is due process of law or procedure established by law. So first, let us understand that how exactly laws are made in India. Okay, so now it is a very fundamental, it is a very elementary question, so which every candidate needs to know as and when they are appearing for the exam. Okay. All right, so most of the laws, okay, so now I will go from one concept to the other, and then like eventually we will fall into, or like eventually we will understand what exactly is the concept of due process of law and procedure established by law. Now there are like various laws in India. Okay, so in the upcoming classes that I'll take for YouTube, so we will be discussing on that particular aspect. So there are like, see, most of the laws that are made in our country, so so those are called legal laws. Okay, now legal laws, there are various types of legal laws. Now most of the laws that are made in India, they are something we call as statutory laws. Okay, just give me a second. So most of the laws, so most of the laws that are made in our country are called statutory laws. Statutory. Now this is a very, very important term for polity, statutory laws. So you must have heard about something called statutory institutions, or like statutory organizations, or like statutory laws, as I am speaking to you right now. Now, the meaning of the word statutory in Indian polity and in the Indian legal system, it means that statutory is that provision that has been implemented in the country by an act passed in the Parliament of India. Very important point, this one. So from now onwards, whenever you hear the word statutory, you know that that particular institution or that particular law has been implemented, or it is ongoing in our country through an act passed in the Parliament of India. Okay, now I'll write this word. Okay, through an act. Through an act passed in the Parliament of India. Passed in the Parliament of India. So suppose suppose I can give you so many examples here. Say suppose right now, let me take up the example. Now I'll give you two examples. So one which is a full-fledged law, and the other which will be an example of an institution which is a statutory institution. Now the first example, one of the best examples that I can give you is the Citizenship Amendment Act 2019. Now, Citizenship Amendment Act is an example of a statutory law that has been implemented in India. Okay, so now if you ask me right now that like why Citizenship Amendment Act is regarded as a statutory law, so because Citizenship Amendment Act was passed in the Parliament of India, because it's an act. It was initially a bill we used to call as Citizenship Amendment Bill. So now that has been passed in the Parliament of India. Now it has become an act. So this particular law that has been implemented in India is an example of a statutory law. Very important. Now, example number 2 is very important. Okay, example number 2 is very important conceptually. Okay, now Reserve Bank of India. Okay, now Reserve Bank of India. Now Reserve Bank of India is also a statutory body. Statutory body. As I have already told you, CAA or Citizenship Amendment Act is an example of a statutory law. It's a statutory law in our country. Okay. Now, Reserve Bank of India is one of the nicest example, where I can make you understand that like what exactly are statutory institutions or like statutory bodies. Now, Reserve Bank of India is regarded as a statutory body because the Reserve Bank of India came into existence in India in 1935 under the Reserve Bank of India Act, which was passed in the Parliament of India in 1934. Now, look at this. So the institution, the body, Reserve Bank of India came into existence or like was established in our country through an act which was passed again in the Parliament of India. So any law, any body which has come into existence in the country through an act passed in the Parliament of India is an example of a statutory law or a statutory body respectively. Suppose if you ask me right now that, sir, is SCORDEMY, I mean like the institution like for which I am taking a class right now, SCORDEMY. Now if you ask me that like if SCORDEMY is an example of a statutory institution or not, then the answer will be no, that SCORDEMY is not an example of a statutory institution because no act was passed in the Parliament of India for the establishment of the SCORDEMY institution. Okay, so this is a very, very important point. So I'll keep the slide. I might be using it again later on. Now, so how are laws exactly made in our country? So there's a small brain map sort of a thing, which you need to understand before going into the concept of procedure established by law and due process of law. So laws, most of the laws in our country are example of statutory laws, which I had already told you, statutory laws, most of the laws in our country, in a country like India, these are all examples of statutory laws. Okay, now laws in our country, so if you ask me that what are the basic steps, which are taken in our country, or like what are the basic steps which needs to be taken through which a statutory law is implemented or is enacted in our country. So now there is a beautiful brain map for it. Okay, after this particular slide, after this particular topic that I will give you right now, then you can ask me any doubts over the live chat. Okay, all right. The first stage of any statutory law, is always the reading stage. It is known as the reading stage, R-E-A-D-I-N-G. It is the reading stage. So reading one, so there are three readings right now. The first reading, the second reading, and the third reading. So reading, now the reading stage means, so now this is a very, very important step in, which is conducted in the Parliament of India. Now reading stage is that particular stage in which a bill is actually prepared. You must have seen, I mean, you must have seen in TVs, you must have seen over your mobile phones or like anywhere, you see that the member of the parliament or like for state legislature for that matter, so it is similar in like both the cases, be it a state law or like a central law, you must have seen that like they discuss a particular bill in the Parliament of India. Okay, so before the bill is actually presented in the Parliament of India, they undergo a stage called the reading stage. In this reading stage, the printing of the bill is actually done. They check if there are any spelling errors or like, if the printing is properly done or not, if all the provisions of the bill are properly printed in that particular piece of paper or not. Everything is thoroughly checked. That is the first stage, the reading stage. After the reading stage, it is presented as a bill. After the reading stage, it is presented as a bill in the Parliament of India. So let me take the example of Citizenship Amendment Bill. Okay, so initially when this bill was presented by the Home Minister of India in the Parliament of India, it was called as a bill. It was CAB. It was not CAA. It was CAB. The bill is now presented in the Parliament of India. Now, depending on what kind of a bill it is, this the Parliament of India has to pass it either in both Lok Sabha as well as Rajya Sabha, or only in Lok Sabha, depending on what kind of a bill it is. Because as we know, there are four types of bill, majorly four types of bills that we have in the Parliament of India or in the Constitution: the ordinary bill, the finance bill, the money bill, and the constitutional amendment bill. So suppose this bill has been passed in both the houses of the Parliament of India. Now this goes for something we call as assent of the president. Assent, that means the president of India, assent of the president. Please make a proper note for it, okay? I mean, like, as you can see that, like, I am using the slide, using the board right now. I highly encourage that you actually write it down in a piece of paper, in your note, in your copy, because this is the most simplified version of like how I can actually put up this particular concept to you. So this is the assent of the president of India. Assent of the president. So again, I'll repeat. First, the reading stage, the actual printing, if there is any spelling errors or not, if all the provisions of the bills are actually properly printed in that particular bill or not, all of them is checked in the first stage. It is presented as a bill. It is presented on the floor of the house, we say. It is presented on the floor of the house in the Parliament of India. So now it goes to both the houses of the Parliament of India, the Lok Sabha, the Rajya Sabha. Suppose the bill has been passed in both the houses of the Parliament of India, Lok Sabha and Rajya Sabha. Now it awaits the assent of the president. Assent means the president has to sign it. Assent means the president has to say yes to it. Now this, the next step, is a very important step. Once the bill is passed in both the houses of the Parliament of India and the bill has been assented by the president, it no longer stays as a bill, it becomes an act. So I can give you the example of constitutional amendment bill has been passed in both the houses of the Parliament of India. Now it has become constitutional amendment or citizenship amendment act. Beg your pardon. Citizenship amendment bill, if it is passed in both the houses of the Parliament of India and has been signed by the President of India, it no longer stays as a citizenship amendment bill. It becomes citizenship amendment act. So now it has become an act. This act right now is implemented. This act is right now implemented throughout the country by the government of India. By the government of India. This is a beautiful concept. It's a pure concept. It is implemented by the government of India in the entire nation. Once it is implemented in the country by the government of India in the entire nation, it becomes a law. That's how a law is made. That's how a law is created in our country. Now, if I ask you, what kind of a law is this law? This is an example of a statutory law. This word is very important for you. If there's anyone who's watching this particular series of classes and you are a beginner, please understand the meaning of the term statutory, which we extensively use in the Constitution of India or in the legal system of the country. So now look at this one. Okay, now I will make this particular brain map. Now if you ever wonder that, like, what exactly are brain maps, now this is an example of a brain map. Now look at this one. I will make this particular brain map perfect right now. Look at this particular stage, bill stage. Now here, to make the note absolutely perfect, to make this brain map absolutely perfect, I will write four things here. Now, how many types of bills are there in the Parliament of India, or how many types of bills can be presented in the Indian Parliament? So there are four types of bills that can be presented in the Indian Parliament. One is the ordinary bill. Ordinary bill has to be passed in both the houses of the Parliament of India, both in Lok Sabha as well as Rajya Sabha. If you are wondering, citizenship amendment bill was passed in the Parliament of India as an ordinary bill. Very important. Okay. Then we have something we call as money bill. Money bill technically needs to be passed only in Lok Sabha. However, it is sent for discussion to Rajya Sabha for only 14 days. So these are things we will discuss in the upcoming classes. I'm just giving you the categorization of bills that we have in the Indian Constitution. The third one is something we call as finance bill. It deals with auditing and accounting, mostly auditing and accounting. So we will learn about it extensively in our upcoming classes. And the fourth one is something we call as constitutional amendment bill. Constitutional amendment bill. These are those bills through which you amended the Constitution of India. Okay, and Article 368, as you might already know, Article 368 is the foundation based on which constitution or the Indian constitution is amended in the Parliament of India. Article 368, amendability of the Constitution of India by the Parliament of India. Now, so these are the types of bills right now. Now look at this one. I have to explain this particular part, and only after that we will go to the original topic of procedure established by law and due process of law. Now, assenting means saying a yes. You are giving a signature. That means the President of India is actually signing that particular document. Once the President of India signs it, it becomes an act, but it is not. I will just use the notation of a tick mark. So that means the President of India has said yes to it. It's a tick mark. However, it is not necessarily important that if a bill is passed in the Parliament of India and then say, suppose I am the President of India, a bill is passed in the Parliament of India, the bill has come to me right now. It is not necessarily important that I need to say yes all the time. I might also say no to it. And that is something we call as the veto powers of the President. It is a very, very recurrent question in competitive exam, irrespective of you are appearing for state services or the central civil services, UPSC, doesn't matter. It's a very, very important information. Veto powers of the President of India is governed under Article 111. Very easy, very simple to remember. Okay. The Indian President enjoys 3 types of veto. Okay, 3 types of veto, very important for your prelims as well as your mains, depending on how the examiner is formulating or has created or has formed a question for your mains. Okay, veto powers. Veto, the word veto means saying a no. One is something we call as absolute veto. Absolute veto. Okay, absolute veto means the President of India directly says no. That means he said that he will not sign it. The bill immediately gets over then and there. There is no further discussion on it. When I say yes, that means I'm assenting to it. I have given my signature to it. That means saying a yes. If I say no, it means the bill is absolutely over. That bill cannot be presented again in the Parliament of India, nor it can be again rediscussed in the Parliament of India. The next is something we call as suspensive veto. Suspensive veto, it is very interesting. Okay, suspensive veto is very interesting. Now look at this. I had used the notation of a tick mark for assenting. So absolute veto means what? The President of India has said absolutely no to it. I will use a cross mark. I will use a cross mark here. Suspensive veto. When I say suspensive veto, it means, now assume that to my left it is the Lok Sabha, to my right it is the Rajya Sabha. Lok Sabha and Rajya Sabha both has passed the particular bill. Now it has come to the President of India right now. Now the President of India neither say yes, neither say no, but he sends this bill back to the Parliament of India, to both the houses, for rediscussion. Okay, so what does he do right now? He resends the bill back to the Parliament for rediscussion. Now, very important, when does the President of India uses this? This power of the President of India is usually used for a controversial bill. Say suppose now the Parliament of India, both the houses, Lok Sabha and Rajya Sabha, has both passed a very, very controversial bill. Now this bill has passed in the Parliament of India and now it has come to the President of India. Suppose me, I am the President of India. It has come to me right now. Now I resend this back to both the houses of the Parliament of India, and I ask them that please rediscuss this again and see if you can make any changes. Okay, so this resending back is something we call as suspensive veto. I will use the notation this. Okay, he sends it back to the Parliament of India for rediscussion. This is an example of something we call as suspensive veto. Okay, however, very important, this was already a question which was asked in UPSC prelims. It was way back in 2012 or 13, I think. We will extensively discuss in our upcoming classes. Okay, so now say I will use the same example. Lok Sabha, Rajya Sabha has passed the bill. It has come to the President of India. Now the President of India resends this bill back to the Parliament of India, both the houses, for rediscussion. Now, what happens if both Lok Sabha and Rajya Sabha again passes this bill? It will again come back to me. Now it is mandatory for me. Now it is mandatory for the President of India to give his assent. I will have to give a signature to it. It's a beautiful concept. This was already a statement-based question which was asked in UPSC prelims before. Okay, so if that same bill is passed again by both the houses of the Parliament of India, it comes back to the president. The president is obligatory. It is mandatory for the president of India to give his assent. He cannot say no to it. Okay. The third one, it is one of the, I would say, for me, I believe this third type of veto powers of the president is one of the most powerful, one of the most extensively, extensive constitutional power that the president of India has. This is something we call as the pocket veto. It is known as the pocket veto. Okay. Now, pocket veto means, it is very important. Pocket veto means, say now, the bill has been passed in both the houses of the Parliament of India. It has come to me right now. Okay, it has come to the President of India right now. I neither say yes, I neither say no, nor I resend, nor I send it back to the Parliament of India for rediscussion. So the meaning is, I just keep the bill hanging for eternity. See, you cannot force the President of India. Now, this is a beautiful concept here. Since the President of India is the executive head of our country, the President of India is the first citizen of the country, nobody can force the President of India to give a decision. It is absolutely up to the President of India what he or she decides. So if a bill comes to me, if a bill comes to the President of India in this particular stage, sometimes he does not take a decision at all. Neither a yes, neither an assenting, neither absolute veto, neither suspensive veto. He just keeps the bill hanging for eternity. And the interesting, I will use the notation this. Okay, he does not take a decision. Now, the interesting fact is this: in the entire history of India, this power was actually used by the President of India, Gyani Jail Singh, against the post office bill. Okay, so it was actually used. So if you ask me right now, so what happened to that bill right now? So which Gyani Jail Singh had used a pocket veto, it is still hanging to this particular date as I speak to you. So the president does not take any decision. He just keeps the bill hanging. So absolute veto means saying an absolute no. Assenting means saying a yes. Suspensive veto means you are resending it for rediscussion, reconsideration back to the Parliament of India. Pocket veto means the President of India do not take any decision. He just keeps the bill hanging. Okay, so this is how laws are made in our country. So now, once you know this, only then it becomes easier to understand a considerably bigger concept of due process of law and procedure established by law. If you have any questions, if you have any doubts, you can use the chat. You can use the live chat counter. If you have any question. Good evening, all of you. Yeah, if you have any doubts till now, till this particular point of time, let me know. Any questions? So you look at the slide here till this particular point of time. So first we have understood what are the stages of actually making a law. So in the first slide, we have understood what actually is the meaning of the term statutory law, statutory institution. So there can be a statutory law or there can be a statutory institution. And then we have understood how exactly statutory laws are made in our country. So this is the exact one. Okay, so you don't need to go through multiple books, multiple pages as in like to understand what exactly this is. So this is a brain map. This is a very, very important brain map. Okay, yeah, right. So any questions, any doubt till this point of time? If you do not have any doubts, you can just type in no doubts so that I can proceed. So since it's a live session in YouTube, this is open for all. This is free for all. So I might not be able to give too much of time, and there's the allocated time just 1 hour. Yeah. Any questions? Okay, all right, I shall proceed. I shall proceed. All right. So now, two of the most important concepts. Okay, so two of the most important concepts in the entire legal system of India, two of the most important concepts that we use extensively in the entire legal system of our country. I would say, we can say these are like procedural laws, or like these are substantive laws, whatever laws that we have in our country. Two of the most important concepts that we extensively use in our country is something we call as procedure established by law. Procedure established by law. This is a concept, okay? Established by law, procedure established by law. And the other is due process of law. I will use the technique of comparative studies again. So this concept you can best understand with the concept of comparative study. We will compare two different theories, two different concepts together, so that you have a holistic knowledge on that particular topic. The other is something we call as due process of law. Due process of law. I think you must have seen, you must have seen in like TVs, you must have seen in like movies for that matter. Sometimes, say, suppose if a police officer, cracks a big case, and like he arrests, like a big goon, or like a big dacoit, or like a big thief, or like big murderer, whatever it is. So when the media goes to him, when the media interviews that particular police officer, what does he say? He says, yes, so I will not be able to give you all the details, but we will take actions according to the due process of law, right? So you must have heard this particular sentence that a police officer might have used in like movies, in TVs, in interactions you must have seen. So we will understand what exactly that topic is. Okay, so first, procedure established by law, very important concept. I'll go a little slow with this because it is a very extensive concept. Okay, so you might have some doubts. If you have doubts, just put it down in the live chat counter. I will address your doubts. Okay, all right. Now, procedure established by law. Now, procedure established by law was already there in the constitution, in the original constitution of India, which was established in 1950. Very important concept. Now you will understand little later why this information is very important. This information is important because when the constitution of India came into effect, we did not have the concept of due process of law. Very important. When the constitution of India was put into effect in 1950, we only had procedure established by law. Procedure established by law is a concept. Procedure established by law is a concept that has come from the British Constitution. From the British Constitution. Very important again. Now, this is important because we already know, or like we must have heard about it, and I'm sure you are already aware of it, that the Constitution of India, was made, which has been drawn from various sources. So the concept of procedure established by law was actually taken from the British Constitution. Now, what exactly is procedure established by law? So I will write here, the definition. Okay, the definition. I will use the word define. So what exactly is the meaning of procedure established by law? So when India became independent, when the Constitution of India came into effect in 1950, during that point of time, only this concept or only this theory was looked into, that like who has made the law. If a law has been made by the Parliament of India, doesn't matter if it's a good law or a bad law, or it's like a pro-citizen law, or like it is a draconian law, it doesn't matter. If a law has been made by the Parliament of India, because we already know that most of the laws, or like majority or all laws, technically if I say all laws in our country is more or less statutory laws, okay, is more or less statutory law. We do have constitutional laws, yeah, but most of the laws that we have in our country is an example of statutory law. So we already know statutory laws are laws made by the Parliament of India. So this is something that we have already understood. Now, procedure established by law is that particular theory, is that particular concept in which if a law has been made, if a law has been made by a legal authority, that law is regarded as a, that law is regarded as a authority, that law is regarded as a legal law. So that means, if I give you an example, if Parliament of India makes a law, okay, if Parliament of India has made a law, it is regarded as a correct law, it is regarded as a legal law. Now the question is, there is an absolute chance, there is an absolute possibility that the Parliament of India might not implement, might not pass a good law, something we call as a draconian law, something we call as like a a non-pro citizens law, okay, something which is not good for the citizens of the country, something which is not good for the people of the nation. So such laws can also be passed by the Parliament of India. So that exactly is the concept of procedure established by law. Procedure established by law states that if a law is made by a legal authority, it is a correct authority, it is a correct law, okay, by a legal authority. So if now we know that, like, if Parliament of India makes a law, it doesn't matter if it's a good law, it doesn't matter if it's a good law or if it is a bad law, okay. So what happens is here, so it is regarded as a correct law, so that law will be implemented in the country. Now you just think about it. Now see, it is very important to imagine few things right now. Just imagine that India has just gotten her independence, okay. The Constitution of India has just come into effect right now, 1950. So in the Constitution of India, we had this theory, we had this concept of procedure established by law. Now when I tell you that procedure established by law is right there, it states that if a law has been made by a legal authority, it is regarded as a legal law. So what happened at that point of time, what happened then was that the government of India started misusing it. And it was a genuine case then. It was a genuine circumstances that has come at that particular point of time. Now, if I am the government of India, now why I said government of India is this: the Parliament of India, the lower house of the Parliament is consisted of the central government of India. So now the government of India started misusing the power of procedure established by law. They started implementing, they started making, they started passing good laws, bad laws, left, right, and center, according to the wish. They started implementing any random laws that they liked. So they started misusing this particular power. So after this, what happened here is this. Now I'll just put an arrow here. So now what happened is this: the Supreme Court of India started taking cognizance here. Okay, the Supreme Court of India felt that, okay, this is not something which is going on right. Okay, so now this is not something. See, because if I am the central government of India, if I have implemented a very bad law in the country, a draconian law in the country, nobody can question me or nobody can take me to the court, because the concept of procedure established by law states that if the Parliament of India or if a legal authority implements or makes a law in the country, it is a legal law, it is a correct law. So there, the government of India cannot be questioned. So this fact was taken up by the Supreme Court. Okay, this fact was taken up by the Supreme Court. The Supreme Court stated that there has to be an accountability, the question of accountability, which is also a very, very important component of good governance. I don't know if you have if you have gone through the concepts of good governance, but yeah, one of the ideal foundation of achieving a good governance in the country is accountability. Now, accountability means you must take responsibility of the after effects after implementing a law. If I am the central government of India, I have implemented a law which is a very bad law, I should be answerable. Okay, I should be open to questions which are thrown to me by the public, by the citizens of the country. But we did not have any provision where the government of India was questioned by the citizens of the country. Okay. So this matter was taken up by the Supreme Court. A very important, now we will go to the second part of due process of law. See, these concepts are very intense concepts, okay? And since it is a YouTube class, as in like it is open for all, so I have taken up this particular topic, okay? It's a very intense concept. Now you must have heard about Maneka Gandhi, okay? Maneka Gandhi versus Union of India case. Maneka Gandhi versus Union of India case. Union of India case 1978. Okay. Now what happened here is this. It's so see, if you ask me what exactly happened that led to this particular landmark Supreme Court case is this. Maneka Gandhi used to speak against the Congress government at that point of time. Okay, so one day when Maneka Gandhi went to the airport, okay, so or like one day when Maneka Gandhi was planning to go abroad for some work, the central government of India decided to seize her passport. Okay, the central government of India, the Congress government, they decided that they will not allow Maneka Gandhi to travel abroad. So now Maneka Gandhi was very agitated, of course. Maneka Gandhi took up this matter to the Supreme Court, and which eventually became Maneka Gandhi versus Union of India case 1978. Now what happened here is this. Under the judgment, the Supreme Court, under the judgment of the Maneka Gandhi versus Union of India case 1978, the Supreme Court stated that from now onwards, there has to be a provision, there has to be a provision for accountability. There has to be a provision to check if a law that has been created in the country is created arbitrarily, constitutionally or not. Only this is not enough. So as you can see, procedure established by law, here what we are checking if a law is made by legal authority or not. Now the Supreme Court stated that under the concept of due process of law, a law has to be made by a legal authority, of course. A law has to be made by a legal authority, of course. That is a minimum requirement. And this provision was also added that the law is constitutional or not. The law is constitutional or not. If the law is arbitrary or not. If the law is arbitrary or not. Or if the law is legal in nature or not. I will write legality. Okay, both of them are now thoroughly checked. These two things combined, these two concepts combined gives you the concept of due process of law. Very important, very important. It's a very intense concept which is very important for a UPSC kind of an exam, especially in mains. If you take up any past questions, you will definitely see like some way or the other questions are more or less related to either due process of law or procedure established by law. Now the concept of due process of law was actually borrowed from the American Constitution. So see, there are conceptual differences. It was taken from the American, it was taken from the American Constitution. So procedure established by law was taken from the British Constitution, and the concept of due process of law was taken from the American Constitution. Procedure established by law, under this particular concept, under this particular theory, under this particular doctrine, so if a law is made in the country by a legal authority or a legal institution, it is considered as a legal authority. Okay, legal law. Okay, so no questions can be asked if the law is a bad law or a good law. So now what happened here is this: the government of India started misusing this power. In 1978, under the Maneka Gandhi versus Union of India case, the Supreme Court stated that from now onwards, two things will be checked: that if a law has been made by a legal authority or not, and if a law that has been implemented by the Parliament of India is constitutional or unconstitutional, is arbitrary or non-arbitrary, is legal or illegal. Okay, now just think about it. This is such a beautiful concept. Now just think about it. What happens right now? What would happen if today, right now in 2023, what happens if the central government of India or if the Parliament of India passes passes an arbitrary law or passes an unconstitutional law? What would happen then? So the answer is very simple. If the central government of India today passes an arbitrary law, an unconstitutional law, a law which is not good for the citizens of the country, the Supreme Court will call the law null and void. Null and void. They will cancel it. They will cancel it under the powers of what? The powers of judicial review. The powers of judicial review. So which comes under Article 13. This is a very, very important concept. So technically, if I tell you, that the concept of judicial review in India came into our country in 1978, so that actually is conceptually correct. These concepts are some concepts which are very important for a UPSC kind of an exam. Okay, so before, see, now look at this one. Now I had already told you that the Parliament of India could pass both good laws and bad laws, right? So no questions could be asked. So the concept of judicial review was not extensively used by the Supreme Court because they could not. The Supreme Court cannot question the government of India. The Supreme Court cannot question the Parliament of India. But after coming into effect of the due process of law, we started having the concept of judicial review, where if a law made, passed, implemented by the central government of India, if it is unconstitutional, if it is arbitrary, they will just cancel it. Okay, and one of the best example which I can cite, where the Supreme Court has actually nullified, has called a decision null and void, has considered that would be the establishment of NJSC, something called NJSC. You can just check it once online. NJSC was National Judicial Appointments Committee. So when BJP government came to power in 2014, so one of the first steps that they took was they had created a body called NJSC, National Judicial Appointments Committee, so which was created for appointments of the judges of the Supreme Court and the judges of the high courts in India. Okay, but however, as we know, there has to be independence of judiciary, and the government of India or the executive or the legislature cannot interfere in the working of the judiciary. So the Supreme Court saw that it was a direct violation of the Constitution of India, and hence the Supreme Court nullified the establishment of NJSC, the body NJSC, National Judicial Appointments Committee. So as we know, most of you might know it, the appointments of the judges of the Supreme Court and High Court is done by a method called the collegium system, or like the collegium method. So this is the comparative studies of study of the concept of due process of law and procedure established by law. This concept is not yet over. I'll have to give you a few more things here, but till this point of time, if you have any questions, if you have any doubts, please feel free to use the live chat counter. If you have any question, you can ask. Acha, lighting problem, please. Okay. Okay. All right. Any question? Now can you see the board? Lighting system ठीक हुई ना? Okay. Tell me if you have any doubts here. See if you have any doubts. see if you have any doubts. You can use the live chat counter. Okay. All right. I shall wait for 30-40 seconds. Okay. All right. If you do not have any doubts, I shall move to the next part. Okay. So this concept is not yet over. So this concept, as in like the comparative studies, is like not yet over. Okay. So now look at, okay, I will use the same method here. Okay. So here it was procedure established by law, PEL, procedure established by law, and I will write here DPL, due process of law, due process of law. Now, if you ask me right now that, sir, what, like where can we find the term due process, beg your pardon, where can I find the term procedure established by law? We find the term procedure established by law in Article 21. Very, very important. This is something that many candidates fail to see when they are studying a book, when they are reading a book. It like doesn't matter what book you are reading, you're like, this is actually Article 21. Article 21, okay, this is the actual line of the full term, like the full term, or like the full line, or like the full definition of Article 21. Right to life and personal liberty, right to life and personal liberty, life and personal liberty, right to life and personal liberty, except according to what? Except according to procedure established by law. So if you are wondering that where we have actually seen the term procedure established by law, we have seen the term procedure established by law in Article 21. So this is the entire sentence of Article 21. Okay, so the concept, see, like the concept, like I have already told you, that when the Constitution of India originally came into effect in 1950, we already had the concept of procedure established by law. So under this particular theory, okay, now observe carefully, under this concept of procedure established by law, which was incorporated under Article 21, the theory, the doctrine of reasonable restrictions came. Reasonable restrictions, very, very important. Reasonable restrictions. That means whatever provisions we have in the Constitution of India, the central government of India can make certain restrictions on it. And like in our normal classes, in our normal app classes, I have already discussed it. But for anyone who is new today in this particular YouTube session, I will tell you, reasonable restriction is a concept which is extensively used by the central government of India even now. Okay, so under this particular concept of procedure established by law, which was incorporated under Article 21, so we have restrictions in almost everything that we have, that is guaranteed by the Constitution of India. So I will give you two examples here. Right to privacy. Right to privacy. We already know right to privacy is a fundamental right. Right to privacy is a fundamental right, but there is a restriction. What is the restriction that the central government of India has given? The Aadhaar Act, the Aadhaar card, okay, the Aadhaar Act of 2016. Now just think about it. When you made your Aadhaar card, you have given all your details. It is a direct breach of your privacy. You have given your home details, your bank details, your blood your blood type, your retinal scan, your fingerprints. Just imagine you have given all your personal details to the central government of India. Isn't that a direct violation? How could the government of India pass Aadhaar Act when right to privacy was a fundamental right? That is because of the concept of reasonable restriction. Extensive. This is pure concept, all of you. It's a pure concept. So Aadhaar Act, under Aadhaar Act, the Aadhaar card that we have in our pockets, that we have in our purses, that we have at home, actually came into existence. This is the restriction that the central government of India has made. Okay, the provision of habeas corpus, right? The provision of habeas corpus. It's a writ provision, habeas corpus. How can I simply explain, or like how can I easily explain what is habeas corpus? Habeas corpus is right against illegal arrest or illegal detention, right? But habeas corpus, something which was again restricted by the central government of India, is what? Is Preventive Detention Act. Is Preventive Detention Act. Is Preventive Detention Act of 1950. Okay, under Preventive Detention Act, the central government of India can simply detain or even arrest a particular person under the basis of suspicion. Just imagine. But under the concept of habeas corpus, you cannot be arrested, you cannot be detained illegally by the police. But it was, again, there was a restriction to it, something like an opposite provision, so which was Preventive Detention Act of 1950. So the concept of reasonable restriction actually came into India under the provision of procedure established by law. Okay, simple. Okay, now coming to due process of law. Now, due process of law, as I had already told you, the basic analogy, the basic concept of due process of law is what? So we check just two things. Okay, now before we used to check only one thing, that if a law that has been made in the country was made by a legal authority or not. So all these law, you can see act, right? Here also Aadhaar Act, here also you can see Preventive Detention Act. These all acts are made by the Parliament of India, by the central government of India. This is a legal body, this is a legal authority, so they can make it is right. Nobody can question it. So now what happens here is this: under due process of law, so they will check if it is a legal authority or not. The law has been made by a legal authority or not, and they will also check if the law is constitutional or unconstitutional. They will check both of them. Now, under the concept of due process of law, the meaning of Article 21, the meaning, if you are taking notes of it, please write it properly. The meaning, the ambit, the meaning, the ambit, or like the entire umbrella of Article 21 was extended. Okay, and remember this provision. Okay, this like under the concept of due process of law, the meaning of Article 21 was elaborately extended. We should all thank Maneka Gandhi versus Union of India case of 1978. Okay, so what did I tell you? Why did this case go to the Supreme Court? Because Maneka Gandhi was not allowed to travel abroad. So under Article 21, what do we have? We have right to travel abroad. It's a pure concept. Right to travel abroad. So the meaning of Article 21 was now elaborated. Now to live a good life, now to live a life with personal liberty, we need right to education. We need right to healthcare. We need right to healthcare. Okay. So now to live a good life, we need right to a good environment. Okay, right to a good environment. All these things right now comes under right to good environment. So all these things comes under Article 21. Now, how do you expect this question to come in your prelims? Okay, so mains, so like from the mains perspective, we have understood the basic theory, the basic, like the conceptual difference of these two particular theory in the entire legal system of our country. Now, how do you expect this question to come in the prelims? Okay, if somebody asks you, or like it can be a statement-based question, whatever it is. If I ask you that, like in India currently, which is the theory that we have in our country right now? Do we have due process of law, or do we have procedure established by law? Okay, the answer is that we have both of them. Okay, it's a very important point. Now, since these all things are not exactly there, not exactly discussed in the normal book Lakshmikant that candidates usually study, just write it down. Okay, just keep it, keep it in your mind that currently in our country, or like currently right now in India, in the legal system, so we have both due process of law and procedure established by law, because you look at it carefully. So now, if a law has been made by a legal authority or not, this already comes under procedure established by law. So under due process of law, the second thing, like the Supreme Court will check if a law that has been enacted by the government is a constitutional law or an unconstitutional law. So two concepts come into play. So technically, if I tell you, we have both of them. Okay, so we both have due process of law and the procedure established by law. Okay, however, if they ask you one single answer, then the answer will be due process of law, because due process of law already consists of the procedure established by law. Okay, so we are done for today. I'll give you 1.5 minutes. Okay, I'll give you 1.5 minutes. If you have any questions, if you have any doubts, feel free to ask in the live chat counter. See if you have any questions. I'll give you 1.5 minutes. Make sure when you are studying by yourself, or make sure if you are currently right now looking at this particular video, or like going through this particular video, make sure you make a note out of it. Okay, it's very important to have a note with you regarding all these concepts. All right. Yes, any questions? No questions? Okay. All right. All right then. If you do not have any questions, so I will wrap up my YouTube session today here. So next class, I will come up with a different topic, which we will extensively discuss. The app-based class, I will have a class after an hour. Okay, so after an hour, the app-based class. So immediately after this class is over, this session is over, JP sir will take your class. Okay, so till then, okay, thank you so much. Okay, thank you so much. Yeah.